Welcome to Legal Analysis. This is a place where I dissect and analyze legal issues. Today we are going to talk about leases and license within the context of the UK common law legal system. If you are new to this channel, please remember to like, subscribe, and share. Come, let's reason together while I illustrate the distinction between a lease and a license. Historically, all land in England and Wales is vested in the Crown. It is therefore impossible for anyone to own the land itself. However, we can own an estate in land, that is, the right to use and control land. It is important to note that there are two legal estates under Section 1 of the Law of Property Act 1925. An estate in fee simple absolute in possession and a term of years absolute, otherwise known as leasehold estate. This actively demonstrates that a lease creates an estate in land and grants statutory protection. Therefore, the holder of a lease has proprietary rights against the land as well as having contractual rights against their landlords. Conversely, a license is merely permission granted to do something, for example, to occupy or to use land. As a result, the holder of a license has merely personal contractual rights against the owner of the property they occupy. I want you to come with me on a journey while I illustrate visually the different types of license.
Types of license.
First, we have what is known as the beer license. A beer license is when a person uses or occupies land by permission. The word permission there is the operative word. That person would use or occupy land by permission of the owner, but has no legal or equitable interest in that land. Such permission is personal to him, to the occupier. Thus, he cannot transfer it. He cannot enforce it against a third party who acquires the land from the owner. His permission can be brought to an end at any time, and he must leave the property with all reasonable speed. If he does not do so, he becomes a trespasser. An example of someone who has a beer license is a deliveryman or a postman. A postal worker delivering mail to a house has a beer license by implication, which can be revoked. A contractual license is where a license arises out of a contract under which the licensee has to perform a service or pay money in return for accommodation, but where the conditions for creating a tenancy are not met. An example of contractual license is when a person buys a ticket to enter a cinema. Contractual license can be revoked due to breach of contract. As the agreement is contractual, remedies such as damages can be sought. The issue as to whether or not a contractual license is binding on third party was discussed in Ashburn Ansalt versus Arnold. As a general rule, contractual license will not be capable of binding a third party. However, in exceptional circumstances, a constructive trust may be imposed to compel a purchaser to give effect to a contractual license. Third, and finally, you have a license by estoppel. An estoppel license arises as a result of a representation by the licensor and a detrimental reliance by the licensee. It is binding between those two parties, but it is also capable of binding a third party. In case you're wondering what is a licensor and a licensee, a licensor is someone who grants license. A licensee is someone to whom a license has been granted. Some license can also be coupled with an interest. For example, if a fisherman is granted permission to catch fish in a private lake, he will inevitably have a license to enter the land, whether implicitly or explicitly. Nevertheless, the license only exists to facilitate the enjoyment of the interest. Such a license cannot be revoked until the interest concerned has ended. The most significant case to highlight the distinction between a lease and a license is the case of Street versus Montfort. The House of Lords held that where the arrangement in question was intended to create legal relations and the occupiers were granted exclusive possession of the premises for a fixed or sporadic term at a rent, then that would amount to a lease. As mentioned before, a lease grants statutory protection and create an estate in land. In Street versus Montfort, Lord Templeman laid down three necessary components which need to be present for a lease to exist. They are exclusive possession, meaning the right to the property excluding others, even the landlord himself. In Abba versus Porncliffe Investment Limited, the landlord reserved the right to enter the property when he chooses. This was held as a license as the occupier did not have exclusive possession. Furthermore, with regards to a lease, the Law of Property Act requires for a fixed term, not an indefinite term. In Lease versus Chatler, there was a lease for an uncertain term, for example, for the duration of a war. This was held not to be a lease, as it was not for a fixed term. For this reason, in Cottage Holiday Associates versus Customs and Excise Commissioners, the courts accepted that the use of a holiday cottage for 1 week a year over an 80 years period was a lease because it had a fixed term. In Street versus Montfort, Lord Templeman appears to say that rent is necessary. However, in Section 105, subsection 1 of the Law of Property Act 1925, it talks about a term of years whether or not a rent is paid. Ashburn versus Ansalt and Arnold, the Court of Appeal subsequently held in a more recent and up-to-date case that the right to receive rent is not a necessary feature of a lease or tenancy. For example, Colby R. in his article argues that only when the House of Lords ruled in Street versus Montford that exclusive occupation was the crucial factor did the law develop a degree of rationality. Exclusive possession used to be the trademark of a lease, but more recently, the common law courts recognize that license of real property, which include exclusive occupancy as a term to benefit the licensee, does not in itself convert the legal relationship into a lease. It is suggested that if there is an exclusive possession for a term and rent is paid, then there is a presumption that the parties entered into tenancy agreement. In other words, there is a lease agreement. There are many cases which, following from the decision in Street versus Montford, that concerned with the distinction between a lease and a license. However, it is important to remember that a lease conveys a legal interest in the land, and a license does not. In Thomas versus Sorrell, it was held that a license properly passeth no interest, nor alters or transfer property in anything, but only makes an action lawful which, without it, would have been unlawful. Westminster City Council versus Clark was referred to in Broughton, where a license agreement was upheld as the council could change the accommodation without notice or require the tenant to share it with any other person. Moreover, the council was entitled to enter the accommodation at any time according to the terms of the agreement. Interestingly, Lord Templeman, giving the leading speech in Clark, stressed that this was a very special case, which was not to be viewed as allowing the landlord to rid itself from the restriction governing statutory security of tenure. In Soma versus Hazelhurst, Miss Soma, the landlady, created a license agreement and reserved the right to share the accommodation with the occupiers or move in strangers to the property. This could be seen as she was specifically trying to ensure that the occupiers did not have exclusive possession. The courts, however, looked at the parties' intention to create a license and not the reality of it. In Anslam versus Murphy, a license was granted to the occupier. The landlord retained a key so that he could enter the property. The occupier was also required to share the basement property and be out of the accommodation for an hour and a half each day. The courts held that these clauses were unrealistic and it was a lease and not a license. Similarly, in the case of AJ Securities versus Vaughan, the Court of Appeal accepted that there was not a joint tenancy, so they could not be deemed to have exclusive possession. In fact, you should know that Lord Denning referred to the judgment of Lord Green in Booker versus Parma, where the circumstances and the conduct of the parties negated an intention to enter into legal relationships. According to Lord Justice Denning stated that we have had many instances lately of occupiers in exclusive possession who have been held to be not tenants, but only licensee. The result of all these cases is that, although a person who is let into exclusive possession is prima facie to be considered a tenant, nevertheless, he will not be held to be so if the circumstances negate an intention to create tenancy. Parties cannot turn a tenancy into a license merely by calling it one. To sum up everything that has been stated so far, as mentioned before, a lease creates an estate in land and grants statutory protection. Therefore, the holder of a lease has proprietary rights against the landlord as well as having contractual rights against their landlord. A license is merely permission granted to do something, for example, to occupy or to use land. This concludes my legal analysis of this subject. Until next time, stay safe.